Hello friends, in the series on the income tax cases, today we will discuss the case of Inox Wind Energy Limited versus Additional Commissioner of Income Tax. This case has been reported in 454 ITR at page number 162. The matter has been decided by Gujarat High Court and the date of the judgment is 31st January 2023. Friends, as all we know that if the assessment is done in the name of the amalgamated company, then this assessment is null and void. For example, if A and B company are amalgamated in company C, and after amalgamation, if the assessment is done in the name of company A and B, then this assessment is null and void. But in this case, facts were little bit different. In this case, the notice was issued to the amalgamated company IR Limited on 23rd September 2019. The notice under section 143 subsection 2 was issued on 23rd September 2019. After issue of notice under section 143 subsection 2, on 25th January 2021, the order of amalgamation came and the appointed date was fixed on 1st April 2020. But the notice was issued from before this appointed date, 1st April 2020. When this amalgamation took place, an email was sent to the assessing officer about this amalgamation. But the learned assessing officer continued with the assessment proceedings. The assessee informed the assessing officer 2 times apart from sending the email on 10th March 2021, by email on 31st August 2021, on 19th September 2021. But without considering this information, the learned assessing officer issued show cause notice to the assessee. When the assessee received the show cause notice, the assessee once again informed the learned assessing officer that the company to whom the notice under section 143 subsection 2 has been sent has been amalgamated. So the assessment cannot be done in the name of the amalgamated company. But the assessing officer go ahead with the assessment. So the issue before the Gujarat High Court was that whether in this particular case the assessment is valid or not. It was the submission of the department that the notice has been issued prior to the appointed date. But it was the point of the Gujarat High Court that even if the notice has been issued before the appointed date, even then the assessment in the name of an person who is not in existence at the time of the issue of the assessment order cannot be made. It was the duty of the assessee which has been fulfilled by the assessee 3 or 4 times in informing the assessing officer that the IR Limited has been amalgamated into the another company. Although when the amalgamation took place, the no objection is sought from the department, and even the ROC also intimates to the income tax department that this company is amalgamated. But even then, the assessee has intimated to the department by email and 3 times more about the amalgamation of the IR Limited. So this is apparent case of negligence on the part of the assessing officer, and the assessment which has been done in the name of the amalgamated company, that is IR Limited, in this present case is null and void. Friends, this case is very important for dealing all those cases in which the notices has been issued in the name of the amalgamated company, or the assessment has been done in the name of the amalgamated company and the assessee has informed duly to the assessing authorities about the amalgamation. So in those cases, the assessment will be null and void. At the end of this video, once again, I am repeating the name of the case. The name of the case is Inox Wind Energy Limited versus Additional Commissioner of Income Tax, and this case has been reported in 454 ITR at page number 162. The matter has been decided by Gujarat High Court and the date of the judgment is 31st January 2023. Thank you, friends.